Good morning. Captain Matt Edwards, retired, here with another one of my Facebook Live Read Between the Lines episodes. And I'm a little bit early. It's 9:52 according to the watch on my desk. But I'm reading through the Canada Gazette that I decided to do it on, and it was from 2011 when they brought in Bill C-55, Minister Jean-Pierre Blackburn. They looked at the benefits that veterans were getting, and they decided they weren't enough. Now, reading through this in preparation for the episode caused me to get a little bit triggered, so I decided to press the button and start recording or making the broadcast. And for example, they talked about the submissions that they had. They had the way they do this, the way they provide, they do this racket with veterans, is that they have been using regulations instead of acts. So acts of parliament are primary law, and regulations are secondary law, which are basically behind the other acts. They're subordinate to the other law. So we have the Veterans Wellbeing Act, as it's called now, but it originally started out as the Canadian Forces Members and Veterans Reestablishment Act. Now that became known colloquially as the new Veterans Charter. And then in 2016, I think, they changed it to the Veterans Wellbeing Act. They keep changing names. Now, a lot of people believe that this is meant to confuse us, and I'm one of those people. They had those names available in 2006. They could have called it the Veterans Wellbeing Act back then, but they didn't. They called it the Canadian Forces Members and Veterans Reestablishment Act. Now, obviously, they put the Canadian Forces members ahead of the veterans because they put it there instead of calling it Canadian Veterans and the Veterans and Canadian Forces Members Reestablishment Act. They put the Canadian Forces members first. Now, that might seem like a silly thing or a simple thing to point out, but you can only get a disability award or pain and suffering compensation when you're serving in the military. Everything else is designed for the post-service veteran. So, what kind of got me upset was I was reading, and I'll read it off to you. I'll tell you, looking at this screen here, I can't help but look at myself. It causes me to have my eyes turn blurry. I think it's these bifocals here. I probably need a new pair. So, these regulations were pre-published for 30 days in the Canada Gazette Part 1 on July 9th, 2001. This period has provided an opportunity for all Canadians, including veterans organizations, individual veterans, and other stakeholders and interested groups, to provide input and comment during that 30-day period. 30 days ain't very much, okay? 30 days in an obscure publication called the Canada Gazette, which I bet you hardly anybody ever heard of before someone like me started talking about it. The Canada Gazette is the newspaper the government has that puts out laws so people can be informed about them. So basically they're saying only the people that were aware of these regulatory changes could comment. Now, what kind of law is that? Now, I've been talking to, yesterday I spoke to a senator's office. I didn't talk to the senator yet, Percy Down. And the reason I call Percy Down from PEI is that he wrote a piece or was interviewed for a story not long ago, 5, 6, 7 months ago, and he was talking about how he disagreed with how the new Veterans Charter was pushed through government. Now, I agree wholeheartedly with this. The government has been using regulatory change and omnibus bills, and it has not followed democratic principles. Okay, democratic principles is our elected members stand up in the House of Commons and they debate things. There should have been thousands of pages of documents, and like the New Zealand, when they changed their War Pension Act, they had like 5,000 pages in the report that was studied for years. Now, Canada's just shoved the new Veterans Charter down our throat. Now, that's an editorial comment. I'm not reading between the lines. I'm giving you my opinion. These bastards did this to save money. Now, during this period, 10 submissions were received. See? Only 10 submissions. 30 days in an obscure government newspaper is not enough to get meaningful input about people who are interested. They say they care about stakeholders, but they don't give people time to provide their input. Now, I think that's garbage. That's anti-democratic. It is just unjust. It is unfair. It should never happen. However, moving on. 4 of these requests, okay, forget that. 6 submissions. This is the part I was going to do. I was going to do this broadcast on the 2015 one about the Reserve Force changes. But I see they mentioned this here, so I decided to do it about this one. So they said 6 submissions. were provided comments for the changes. 5 commented on the difference between the earnings loss benefit provided to a reservist, a Class A reservist, and Class B reservist. Now, in 2015, the government addressed this on the 8th of April. They changed it, and they said it was inequitable to compensate a part-time veteran differently than a full-time veteran. Now, this is where the reading between the lines comes in. When the government admits something is inequitable, they're saying it's unfair. Now, when you're telling it's unfair to treat a disabled part-time veteran different than a disabled full-time veteran, they're basically saying, they're admitting they discriminated against the disabled veteran. So between 2006 and 2015, the government had a rate for the disabled part-time veteran that was different than the disabled full-time veteran. So using the old thing like Major Henwood, back in 1999, was being interviewed for the Senate Committee on National Defense and stuff, and he said, why are my legs worth less than a captain or a general's legs? Now, why is a disabled part-time veteran's money, the earnings loss benefit, worth less to the government than a full-time soldier's? See, I don't like discrimination. Nobody should like discrimination. Nobody likes to use the word discrimination, but when you treat two different people that are very similar, but they come from different groups, like part-time versus full-time, and you treat them in a different way, that is the very definition of discrimination. Okay? So nobody went to the Canadian Human Rights Commission. I tried, I believe. They ignore me, like usual. But anyway, in 2015, they decided to make it everybody gets the same 75%. Now, a brief history of the earnings loss benefit. The new Veterans Charter brought in the new earnings loss benefit, and they based it on the Service Income Support Insurance Plan. So they took an existing wage loss replacement plan, that's what Canada Revenue Agency calls it, and they adapted that, they copied that, and they brought it into law. So part of that was in 1991, the Service Income Support Insurance Plan added the reservists to that plan, that program. So at the time, it was voluntary, and you didn't have to buy into it. So nobody bought into it, and so in 1999 they decided to make it mandatory, and then Treasury Board paid the bill. Now, even though they paid 100% of my premiums when I was in the reserves, it did not pay it on their behalf. They paid it on my behalf, okay? If somebody pays something on your behalf, they could have gave me the money, and I could have sent a check to the people who have the insurance. Now, prove to me that the government actually paid it. I don't really know if they did or not. Now, I have a very nasty anecdote about that because I called Manulife and I wanted to claim on my taxes my career premiums. My reasoning is that even if the government paid it, I earned it in service. So therefore, I wanted a copy of it so I could a statement on it so I could then send it to Canada Revenue Agency and save on my taxes. When I called the guy at Manulife, I didn't get the usual prick, Christopher Anderson, but I got a different fella, and he said, "What do you want that for?" When I asked him for a statement of my career earnings, and he said, "Well, you want that for taxes?" I said, "Yeah, I do. I used to be a Canada Revenue Agency tax collector, and I know the rules. I know that I can claim my career premiums." He said, "You didn't pay a dime anyway." I said, "Listen here, you son of a bitch. You telling me my service is not worth anything? You telling me that my service is not worth 100% of the premiums that the government paid?" You see, if I really wanted to be technical, I could bring up the Watts Tax Court of Canada case in 2004 or 6 or something like that, and I could say, well, they were talking about the word substantial, and the word substantial they defined as 85% or more. So if someone's paying 85% or more of the premium, it's the same as all of it. So when the government pays 85% for the regular force soldier, they're basically paying all of it, right? So the difference between the reserve and the reg force is only 15%, but according to the courts, that's not enough to qualify. So really, the guy, he was being a jerk, okay? And I believe that what they were doing is trying to protect the government's tax base, okay? Why should the employee at Manulife give a shit about taxes, okay? It's not supposed to be relevant to them. Now, in the law, there's a thing called relevancy and mootness. It should have been moot to him about providing me with a statement. Now, I probably called the wrong people. Now I tell veterans to call the Canadian Forces people, because the premiums you get paid from the Canadian Forces. Why should you go to the insurance / administrator? It is absurd for them to be providing it. Now, the reason I bring this up, and if I haven't covered it before, I'll briefly mention it. Louis Dufour, a veteran in Quebec, he provided me with his career statement. Now, he served from 1988 to the year 2000. He was a paratrooper in the Airborne Regiment. Now, The thing is, when he asked for a career statement of his premiums, they told him he paid $239 or something like that. Now, you can't tell me, and I ask you, write in the comments, do you believe that a soldier could be covered for 12 years worth of insurance for long-term disability for about $25 a year, $2 a month? I don't believe it for a second. So I believe what their plan is to save on taxes. If they underestimate the amount of money that you paid in as a premium, then you can't get a tax refund. That's my theory. Prove me wrong, government. Okay? That's a serious allegation. They are falsely sending statements of career contribution to people to minimize the tax refund. If I'm right, I'll put that proviso in there. Now, Louis had a friend who served 25 years, and they told him his career contributions were something like $2,500. So that's $100 a year. I don't believe it, okay? It doesn't have the air of reality, as they say in various cases that I've been looking up, right? Anyway, they did change it in 2015. And when they changed it, that caused me personal issues, okay? I was having a hard time to get SISIP, Service Income Support Insurance Plan. First told me I had to be hurt in service, and then after they accepted that, they approved me in March, April 2013. Now, by the time 2015 came, I had just started the veterans advocacy stuff, okay? But I was much more cognizant of the changes back then. These days, I'm not watching the changes because it burns me out. So back then, I was watching it very carefully, and I saw that they were going to change it for the reservist. And when they said that they're going to change it for the earnings loss benefit, I contacted my wage loss replacement administrator, Manulife. And I said, excuse me, but are you going to match what Veterans Affairs is doing? And are you going to pay me 75% just like they do for the Reg Force and the reserves in the other department? Manulife sent me a letter, and you can look this up on my Facebook group. I've posted all of this stuff because I've give up my right to privacy voluntarily to try to get this stuff fixed. So I posted the letter, and you can see it for yourself. So some date early in 2015, they told me I had to contact Veterans Affairs. So then I contacted Veterans Affairs, and they told me that I had to contact the Department of National Defense SISIP program because I wasn't in their system. Now, that is awful. You have two departments bouncing a veteran back between each department, each refusing to pay. Now, it's absurd, okay? You're not supposed to do that. Now, I spoke to the Office of the Veterans Ombudsman General 1-800 line yesterday for 2 hours and 20 minutes. Don't even think I posted very much, except that I called her and had a long call. But one of the things I said to him is that if you get medical release in the military, you're supposed to be a dual client of Veterans Affairs and the Department of National Defense. And then I told her about the 2003 Martin Supreme Court of Canada case where you had a New Nova Scotia workers' compensation person who had chronic pain. So because he had chronic pain, they treated him differently than other people. And they denied him access to the workers' compensation system. So what they said was, it is discrimination to base a denial of belonging to an institution based on some weird reason. So they said that this condition didn't qualify, and that was discrimination, they said. Well, I say the same thing applies if you're a regular force or reserve force person, and they say that medical release is the gateway, the entrance to the Department of Veterans Affairs, then they should live up to their word. The VPPM 5, Chapter 3, Section 3.17, I got this crap memorized, states that this is to be the case. Now, they designed the system to leach, to be a parasite to the Service Income Support Insurance Plan, because they don't pay unless you need more money after the SISIP program. That's insane. I'll get into that a bit more if I don't wear myself out here, because I saw it down here in the Canada Gazette from 2011. Let me get the reference number, although I'll post it later and it's in my group. Let me tell you what the actual words say. It's from volume 145, number 21, October the 12th, 2011. Okay? So they had the Canadian Forces members, regulations amending the Canadian Forces members and veterans reestablishment and compensation regulations. So they give notice to people, and then groups like the Royal Canadian Legion and the ANAVETS and all these other different groups, the NATO veterans. I don't know them all. I hardly know any of them. But then they, monitoring this stuff, they look at it and try to find holes in it and try to submit different things. Now, what they said here is that what really got to me, why I decided to start early this morning instead of wait till the 10 a.m. Newfoundland Standard Time, 0830 Eastern Standard Time. It's probably too early for many people. But I saw here that they said, quote, now, I hope you got your sarcasm meter turned on. Income matters. A minimum level of income is necessary to ensure that basic needs, such as food, shelter, and clothing can be met. Now, that's welfare. That's welfare, okay? You know what you can do with welfare? You can shove it up your fucking arse if you think that you can send a veteran who went to war healthy, and after they went to war healthy and came back disabled, and then you want to give them welfare, you go fuck yourself, okay? Okay, I hope you haven't got too many kids watching this, because it's going to have some vulgarities when they do shit like this. This ain't right. Myself and Arnold Murphy, he's a frequent tagger. I tag him and he reads all my stuff. He believes there's a racket on the go, and I believe it's a racket too. And they want to only pay if we can't pay with other things we have. So they say income matters, but I had a veteran, I think it was Rob Pizzio, made a comment yesterday after my broadcast, or after I read some of my stuff, and he said, Matt, if you say pensions are property, not income, how come there's taxes on it, income taxes? And he said, this might be a dumb question. I said, Mike, it's not a dumb question. It's a great question, okay? The reason for taxes to be applied on receipt of a pension and not when you make the contribution is because the government wanted to have an incentive for people to have pensions. So they made the contribution tax-free, and they made the period that it's in the pension tax-free. But then they only defer the taxes to when you draw out the money from your savings, okay? So a simpler answer would have been, Mike, I know, I said Rob before, I think it was Mike actually. Mike, the reason I say that the Canadian Forces pension is property is because the Supreme Court of Canada ruled that way, okay? That would have been a simpler one than explaining the tax implications, but both get us to the same place, okay? You had a guy who was divorced, and his wife, his ex-wife, wanted half of his pension. So they lived in Nova Scotia. At the Nova Scotia Court of Appeal level, her lawyer or her said that it was income, not property. And then it got overturned at the Supreme Court of Canada, and when they said it wasn't income, it was property. So it was a binary choice. It was a 1 or a 0. It was either income or property. That's it, okay? You can't disagree with the Supreme Court of Canada. If you disagree with the Supreme Court of Canada, you're wrong, okay? Anybody in the government who says the Canadian Forces Superannuation Act is income, they're wrong, period. End of story. Unless you don't believe in the rule of law and having the highest court in the land, having the prerogative to shoot down all the other cases along the way, and then come out with a final verdict that says this is the way it's going to be. Is that understandable? I mean, we have to have some sense of jurisdiction, like who sets the rules. And the Supreme Court of Canada is the highest bar that you can ask for in a common law democracy, because the common law, if I haven't mentioned it before, is case law, judges. So we have things from the past that have been to court, and then a precedent gets set. So because they set a precedent, then it's a law. And the burden of proof is 51%. Okay, so you have your side, they have their side, you go to court, you have a dispute, you tell it to the judge. If the judge believes you, or the judge and jury believes you, then 51%, you win. And after it's decided that, it's 100% true. Before, it might have been whatever, like people were waffling, which is right, which is wrong. But after it's been heard, and after it reaches the highest court in the land, it is absolute. Okay? Now, the provinces might have the ability to change that because they own property and civil rights, and courts are generally in the provinces. But the federal government can't. So the federal government can't say, we're going to pay people, something and change the definition. They just can't. They're not allowed. Jurisdiction. Anyway, I wrote a story about this years ago. I think I called it Income Matters, because they say income matters, but you see, people are not getting income. If you get a pension, okay, the old Pension Act, not talking about a Canadian Forces pension, the Canadian Forces Superannuation Act pension. When I was talking to a veteran in Ontario recently, he was trying to tell me, or somebody, maybe it wasn't him, was saying there's a difference between a superannuation pension and a disability pension. Of course there is. But you know, according to that same case I mentioned before, the Clark versus Clark Supreme Court of Canada, 1990, where they said pensions were property, and it was about the Canadian Forces pension, right? It was about the Canadian Forces Superannuation Act, so it's not like I got to bend it and say it's exactly like some other case. It's that pension was the subject of the case. Now, I lost my train of thought. Anyway, so the disability pension under the Pension Act is a capital payment meant to replace your body. Now, if you get hurt in a lawsuit, if you get hurt in an accident or something, if someone didn't salt their sidewalk, you were going out to visit their house, and then you slipped and fell. Well, they were negligent by not putting salt there, or some kind of, or they didn't beat it off with a shovel or a hammer or something. And then because you got hurt because of their negligence, they are at fault, and they owe you money to repay you for the damages they provided. Now, so the Pension Act, I sent a picture to Dan Slack, the veteran I was talking about up in Ontario, and the thing is, in 1953, when they established the Crown Liabilities Act, now it's called the Crown Liabilities and Proceedings Act, but in 1953, when they decided to put in the Crown Liabilities and Proceedings, that's the new name, they decided to put in a bar to lawsuit for people who got a pension, Act pension, or something like that. And it's Section 9 of the Crown Liabilities and Proceedings Act. Now, they also put a corresponding provision in the Pension Act. I believe it was Section 116. I could look it up if I cared. But they put a corresponding provision in the other act to refer to the other act. So you have, that's the way laws are supposed to work. If you have one law wants to talk about another law, you have to show that they really meant it by changing both to refer to each other. That's my understanding of the rules from reading various cases. So if you get a pension, you're getting paid back for your injury in service. Okay, I can refer to two different things that just popped into my head. Income Tax Bulletin 365 R2. R2 means revision 2, so they had 2 previous revisions, and that's about the receipt of damages. So they said in that if you get a sum of money to settle a legal dispute, it could be before the case or it could be after the case, but if you get a sum of money in receipt in relation to settling a lawsuit, you have gotten damages, and it is not to be charged as income. Now, if you look at that and then think about the fact that the Pension Act is a replacement for a lawsuit and tort, then that explains why we have a tax-free pension. Now, workers' compensation is also supposed to be a substitute for a tort lawsuit. Tango, Oscar, Romeo, Tango, tort lawsuit. So, anyway, so when they started talking about getting back to my subject, I'm reading between the lines from the Canada Gazette in 2011, where Bill C-55 was brought in by the Conservative Government of Canada, Jean-Pierre Blackburn. And they said that income matters, income brings health. Well, they weren't even talking about income. See, if you replaced the Pension Act, and the Pension Act was a capital payment to replace your bodily loss, and they replaced that with the new Veterans Charter, then you split up the capital payment, but you can't call it income, goddammit. It's not income, it's capital. Now, if you want to know the difference, there's income from employment, income from an office, income from business, income from property, and income from capital. Canada has 5 sources of taxation, and those are the 5 sources. Now, if they really, I hate it, the way things go in my mind, get all this stuff floating around. They have a catch-all provision in Section 3 of the Income Tax Act, and basically if they want to, they can say anything is taxable. But they did specify certain things in Section 5 of the Income Tax Act, and Section 6 is where they put SISUP, because they call it the fringe benefit. Now, I'm getting off topic a bit, but I submit that anything that is paid, say you pay a earnings loss benefit or an income replacement benefit to a disabled soldier who went to war, you're not giving them a fringe benefit. A fringe benefit is something over and above their pay. You're giving something that's a core benefit, a basic benefit, something that you have to assure the veteran, the soldier, before they become a veteran, that they will be covered. They will have peace of mind to go into combat, just like Sir Robert Borden said in 1917 on the Vimy, on the field of Vimy. Because that's what I said, and that's why it's in my head. I was repeating what I said to the Office of the Veterans Ombudsman lady yesterday. I said soldiers today, just as 1917, need to have peace of mind about, before they go into combat, that they're going to be took care of if something happens. They could get killed. They want their family took care of. They could become disabled. They and their family need to be taken care of. So unless you have peace of mind, you're harming our national defense public policy. You need soldiers. Soldiers need assurance. So you had to provide them with that insurance. I'm a very logical person. I'm not doing this to get people more money. I'm doing this because it's right and not wrong. Okay? They never should have brought in a system that looks after people only if you can't look after yourself. That's what they're doing here. They brought in a welfare system. Okay? We already had a welfare for veterans. It was called the War Veterans Allowance Act. But when they brought in the new Veterans Charter, they put a updated that into the new Veterans Charter, and they called it Canadian Forces Income Support. Now, nobody hardly ever gets that. The original design in the Canada Gazette, and I'm getting off topic, but I'll tell you about the 2006 Canada Gazette, it said that after you do rehabilitation and you're ready to return to the workforce, but then you can't find a job. Well, the Canadian Forces Income Support is there as a safety net for you. Now, where was that safety net when Gina, I can't pronounce her last name, Pacwa something, she's from overseas, but she served 6 years, became injured, and after they kicked her off the rehabilitation medical program because she got hurt in a motorcycle accident, they cut her off the earnings loss benefit. Where was the income matters and health matters then? So they put all of this Canada Gazette stuff out there for people to read and pretend that they care, but when it comes down to it, they cut people off and they don't give a crap. They ought to have basic human empathy. Okay, they ought to be able to look at the person that was injured in service, and they ought to be able to put themselves in their shoes. And they should say, if I was that person in that motorcycle accident, I think I would like to have a break cut to me. I'd like to have some wiggle room. I wouldn't want to be cut off because of some case manager's judgment that you can't participate in rehabilitation because of your accident. So because you can't participate, you're kicked off. I mean, what kind of attitude is that? Now, it's not... Oh, where I was going with that? She should have, if she was kicked off the rehab program, she should have got the Canadian Forces Income Support. I mean, they don't even realize that one program is supposed to pick up for the other program if they operate it the way they say they're supposed to operate. Anyway, let me move on a bit and see what drove me a little while ago. Because that's why I started early again. Oh my, it's so hard to read this stuff without cursing and swearing and whatever. But basically, okay, they said that they had to operate on the same terms as CISA. They mentioned, it was talking about 2 submissions asked for age 65 compensation. Now, as I explained to 2 Office of the Veterans Ombudsman people, because I spoke to a senior person after I spoke to the junior person at the 1-800 line. So last week she couldn't get a hold of me on my anniversary, and so she called me back late on Monday. And then her phone died while we were talking, so I only got a short call, but I was tired of talking to her too. Now, what I was saying is that they caused this problem, okay? The Pension Act paid for life, so there was no problem with after 65. Now, when they brought in the new Veterans Charter, they decided to copy CISIP. And they decided to copy CISIP, which ended at age 65. So they blindly copied the ending at age 65. So when they asked for submissions in the 2011 Canada Gazette, 2 submissions were about the failure of the government to pay after age 65. But they created the goddamn problem, okay? So why do we expect? How can we look at them and expect them to provide a solution when they caused the fucking problem, okay? Okay, tell me that, riddle me that, okay? Because when I was talking to the Veterans Ombudsman yesterday, I said the same thing about infernal review, because that was the subject of my call. I called up and I asked them to review my situation to see if they could find some way to get a reasonable decision about my mistreatment at Veterans Affairs. So I asked them to basically be reasonable, which is part of the government. They have a duty to act fairly. Now, all this stuff is you're asking them to decide that they're wrong. Now, it would take a big person to admit that. So if you do an infernal review, I'm going to have myself trained to say that instead of internal review soon. But if you do an infernal review, you ask them to review their own decision. And then if they decide no, you ask them to review their own decision again. And as I explained to her, you're not supposed to provide an incentive to save money, because they might have every intention of paying the person on the very first application. But the way they wrote the act is that they don't make a payment until the final decision is made, so you could apply. They might want to give it to you. They might say, hey, we can save money by denying him on the first and then approving him on the second. So they can drag it out for, say, 2 years, and we all know how they aren't very timely in their decisions. And then at the end of the day, they don't go back to the date of your application. They go by the date of the decision that you are approvable. Now, there's a problem with that, as I told the OVO. I said the problem with that is that in the common law, and we are a common law democracy, the person who hurt you owes you from the day they hurt you. You can't say it's only for if you had a coma. Say you got injured in that walking up the steps thing, walking up the sidewalk or whatever. You go into a coma. A year later you wake up. They can't say we're only going to pay you now after you apply. They have to base it on the date of the injury that they caused you. Now that is the fundamental problem with the new Veterans Charter. Okay, the new Veterans Charter tries to say that they'll only pay you if they decide that they will accept you on this date. Now, adding to that, and I intend to do, but I mean, there's not much to it really, they also put into the act that there's 0% interest. Now, can you owe someone for their physical and mental injuries, and then, first of all, not pay them till you approve them, and then when you approve them, not give them interest? I said, compare that to the Pension Act. The Pension Act had 3 years worth of retroactivity. 3 years. Now, under the new Veterans Charter, you have 0 retroactivity. Under the old Pension Act, you had 3 years worth of retroactivity. Now, before you get too excited about how good the Pension Act, the reason for that was because of the delays that Veterans Affairs was taking so long, they decided to make it a 3-year window that people, while they're waiting to get approved, they put a 3-year retroactive period, but it's not that they're saying we're going to be good to people and give them 3 years. It was because they were so fucking bad in processing the paperwork that they put 3 years in there to give themselves time. That's what I've read. I mean, that's my understanding of it from reading in the Hansard and whatever. So what they need to do to fix this, because I always say I don't just want to complain about things, I want to tell them how to fix it. You got to go back to when the event happens, that's when you had to pay someone. You had to get rid of the rule that says you cannot pay someone until after they decide that they will accept you. And then you had to get rid of that 0% interest bullshit. The Bank of America Supreme Court of Canada case in the year 2000 said that everybody that's been damaged and has to get a restitutionary payment has to get compound daily interest as a minimum. Then I told the OVO about the Interest Act. So the Interest Act states that the government will pay 5% compound, I don't know if it's compound, but 5% interest if the act or some other regulation doesn't specify it specifically. The federal government has an Interest Act. Now, you have an Interest Act that tells you that the government will pay 5%, but you know, they put into the Canadian Forces Members and Veterans Reestablishment Act 0% interest. Now, I claim that there is a repugnancy in the law. That's what it's called when you have two laws that ignore, conflict with each other. So you have on the one side where you have a disabled veteran and they want to save money. So I think they copied the workers' compensation systems. If I called the Newfoundland Workers' Comp, if I really cared, and I said, listen, under the Newfoundland system, like, how much interest would I get if you approved me retroactively? I suspect they'd say 0. That's where I think they might have got it. Why do I suspect that? I'm rambling a lot, excuse me, but I remember watching that video of the Town Hall Dog and Pony Show with Minister O'Regan and Deputy Minister Natinchuk, if I pronounce it right. And I think I asked, but it might have been someone else, but I think it might have been me. I said, Minister, can you explain how come you came up with $20,000 under the allowable earnings under the pension for life? Words to that effect. The deputy minister said that they called around and saw what the workers' comp does and that $20,000 was the best one out there, so they used the best one out there for the veterans. Now, as I explained to the OVO and everybody who would listen the last couple of years, because I've been on this topic for a couple of years, this particular issue, as I discover issues, I put it out there, but I keep discovering new ones. Now, the $20,000 exemption from income is a good thing on paper. If you don't have anything else, it's also a good thing. But if you have the Canada Pension Plan Disability and or the Canadian Forces Pension, then you're fucked, okay? You believe the minister. You go to work. You make $20,000. at $5,301, the Canada Pension Plan, if you have it, cuts you off. Now, if you have the Canada Pension Plan and you got kids, they get the Canada Pension Plan Children's Pension. They get cut off. If you have the Canada Pension Plan Disability Payment and you have the Canadian Forces Disability Payment, then you get cut off there as well, because they put in Section 23(1) of the Canadian Forces Superannuation Act, if I recall correctly. I'm pretty sure I'm right. They put in there that if you lose your Canada Pension Plan Disablement Pension, you'll also lose your Disablement Canadian Forces Pension. Now, is that worth the effort of trying to get back to work, like the minister said, having a $20,000 exemption when another government department had $5,300? I say they didn't do their due diligence again. Departments are doing things without checking with the other department, just like the double dip clawback, where the Department of National Defence takes into account the Canada Pension Plan, the Canadian Forces Pension, and so does Veterans Affairs. And then Veterans Affairs takes CISIB into account as well. Now, I shouldn't do this, but I saw Bud Burker's watching. Bud, you're an accountant. Tell me what that's called. I call it hashtag double dip clawback. The Department of National Defence claws back the value of the Canadian Forces Pension, and they also claw back the value of the Canada Pension Plan. Then when the Veterans Affairs people top up that program, and they claw back the Canada Pension Plan for the second time, and then they claw back the Canadian Forces for the second time, and then they claw back CISIB for the first time. So basically you get screwed over and over. Now, I've been trying to get the government to admit that, and they haven't admitted it. I brought it over there to the Minister of Veterans Affairs at the time and the Associate Minister of National Defence, Seamus O'Regan, shameless. And then I thought they would fix it, because I know the government doesn't act fast. Look, in 1999 or the year 2000, they said that the Reserve Force Pension Plan was a priority issue for the government. It never came into 2007. Now, 7 or 8 years is not a priority in my world. You need to have immediate action drills. You need to have things that you have to be able to drop everything and do something about it. Now, I think that the double dip clawback is what I would call an immediate action drill. Okay? You have people that served the country, got hurt in service, and then because they had got hurt in service, they also got the Canada Pension Plan or the Canadian Forces Pension, and then the Department of National Defence saves once, then Veterans Affairs saves for a second time. Now, one of the veterans I saw watching, I'll mention his case without his name, he had Veterans Affairs taking into account his Canada Pension Plan, despite the fact that Great West Life was taking it in, where after service, he served from 1977 to 2004. After service, he went to work for Canadian National Railway. After he served there, he got hurt in a car accident off the job. So then, when he got his insurance, they got him to get the Canada Pension Plan. Well, when VAC had him on the earnings loss income replacement benefit, they took the Canada Pension Plan into account. He told me it was about $1,200 a month. I said, well, $1,200 a month times 12 is $14,400, and it was 2010 it started, till now it's 10 years. So we have $14,400 times 10 years, $144,000 that somebody owes you. It's either the Great West Life owes you, it's either Veterans Affairs owes you, or a combination of both. But somebody owes you $144,000 plus compound daily interest, and possibly more, because it's what you call a peace of mind contract, right? The Service Income Support Insurance Plan and all the stuff paid by Veterans Affairs that are like insurances are what you call peace of mind products. You're supposed to have what Sir Robert Borden said in 1917, peace of mind. You're supposed to get only one thing from an insurance contract, a psychological benefit called peace of mind. Now, where do we go with all this? One of these days we're going to sue the fuck out of these pricks if they don't start fixing it voluntarily. I've been trying to work the political angle by talking to members of parliament and stuff, talking to senators, but the thing is, they don't seem to want to act very fast. Now, I don't trust the courts. Now, you might think that I'm paranoid by that. I have people that say to me that you should trust the courts. Well, when you see a judge say that, the lady should have crossed her legs to avoid being raped, I tend not to trust judges after hearing that. Okay? If I read a case myself about the Arthurson case where a veteran from World War II with PTSD couldn't manage his own affairs, so Veterans Affairs was looking after his Pension Act pension, and then they didn't give him interest, and then after he won in the courts, the Supreme Court of Canada overruled it. So I'm there saying, why the fuck did the Supreme Court of Canada rule on that way? That person had his money being held by Veterans Affairs, so they ought to have paid because of the fiduciary duty that the government was said to have there. They had a duty to provide him with interest. I think the cost, $1.07 billion, was the reason why the Supreme Court of Canada ruled in favor of the government. Right? That's what I believe. Now, I could be wrong, but I think I trust myself, my own judgment, rather than trying to believe other people. They want us to believe in the bridging, okay? I'll get into that because I talked about the age 65 thing. They want us to believe in the bridging, and as I explained to everybody under the sun recently, including the people here watching, if you watch one of my previous broadcasts, in 1964, on the 9th of February, Honorable Judy LaMarche, who was the Minister of Health and Welfare, who brought in the Canada Pension Plan Act, which, by the way, wasn't an easy process. Okay, they brought in a pension that was supposed to be multi-employer, contributions-based, and this and that, and everybody had their own opinion, so it was a big fight for 3 or 4 or 5 years before they finally passed it in 1966. So in 1964, she was asked by a member of the opposition, listen, what about a public servant who gets disabled? Do they get both disability pensions? She said, of course. Now, if you are supposed to get both of your pensions because you became disabled, and I'm going to bring in the public service one and equate it to the Canadian Forces one or the RCMP one too. Now, if you're entitled to your disability pension under the public service, RCMP, and the Canadian Forces pension, why the fuck can't you get your Canada Pension Plan disability too? She said it would, and she brought in the Canada Pension Plan Act. Now, where I was going with that is I said to the Office of Veterans Ombudsman, and I said to the Senator Down from PEI, I said, listen, the government moves slow. Everybody knows that. What are the odds between 1964 and 1966 that when we get those letters about bridging, they always say, the government designed this and they integrated and coordinated this back in 1966. Now, you want me to take you seriously? Tell me another lie like that, but make it more reasonable, right? Okay, 2 years. Between 1964, when the record on the Hansard shows that it was supposed to be both, and then between that and 1966, which is in the bridging letters, I say they're telling us that's lies. That's garbage. Okay? So what I said to the OVO, and they have more resources than I do. They have 30 employees and a budget of about $5 million. Now, the lady told me, and I haven't looked it up yet, that they had a recent report, and I heard it was scathing, but I'm not sure, from the 4th of August this year, and they did an internal report on the Veterans Ombudsman. I'll have to look it up later. But my point here is that the government should look into what the record is. What is the legislative history of Canadian Forces Superannuation Act Section 15.2b and Public Service Superannuation Act Section 11.2, and I don't know the RCMP one. But if we knew the date that they put those laws in place, and it wasn't 1966, then we have proof that in those bridging letters they're lying to us. Okay? That's the way I look at it. Now, I don't know. I haven't had formal training. I haven't gone to school and learned how to be an investigator. But after being a collections officer for CRA for 16 years, I think I know how to investigate things. For example, I probably wouldn't tell you about this, but his case became CRA took him to court. I saw there was another CRA employee looked at an account that I was working on. So I go to Fred and I say, Fred, how come your name's here? Why were we looking at this account? Oh, his wife called in and said that, was going to change her name to his after getting married. So then I looked up that and looked up this, and then I dragged out that he was an engineer that registered a company down in the Turks and the Caicos, and he was defrauding the tax people, government, because he was really him as a company, but he was getting the payments through the company, and he had the company set up as an offshore company. So we went after him and prosecuted him. And I mean, that was all because I started digging it and pulling on the strings. It sounds egotistical, I'm good at that kind of stuff. Maybe it's my obsessive compulsive personality disorder, but when I get something in my crick in my whatever, when I get bugged by something, I start looking into it. And then I try to find out how to find out a fix for it, right? Like, I'm hoping that the Senate might be able to put the brakes on the next time they want to fuck us over in the new Veterans Charter. Right? Because the Senate has to approve what comes from the Parliament. That's just the way the democracy works. But in the meantime, we need to start speaking up, okay? Unless someone speaks up, no one's going to speak up on your behalf. To hope that someone will speak up on your behalf, they might never do that. Look, I don't want to be making these videos. I would rather be living my life as best I could and trying to get by. But these people said things, and I got to look it up because that reminded me. I mean, they said the intent was that basically the premise of the benefits is based on the assumption confirmed by the body of literature. Now, that's what you call a blanket statement. Reading between the lines, they didn't say where it said that, but they said confirmed by a body of literature. See? Now, if you were reading that Canada Gazette without someone like me, and that's why I started this particular broadcast called Reading Between the Lines, you have to know how to read the government jargon and see what they're really getting at. that additional income accrued to the person impacts their life beyond a simple transfer of cash. Well, that's kind of obvious. Income procures goods and services, which in turn enhance a person's well-being. Well, I mean, you got to have money to buy things. We had to have a transactional system, and money is the thing that does it. Financial well-being, or the ability to have a standard of living which covers living expenses, is the basis upon which all other... Listen, the thing is, back in 2011, when they gave us a real big hint, they based a lot of the stuff on the low-income cutoff. Now, that's Canada determination, certification, of what does a family of four need to provide the basics of human life. Now, so the government decided to set the minimum standard for what a disabled veteran will get will be based on the low-income cutoff. Now, if you base something on a welfare-type program, you have welfare. I was trying to remember a saying because it crossed my mind. If it looks like a duck, walks like a duck, and quacks like a duck, it's a duck. Okay? So you have all these things that the government brought in. They said this, they said that, but, it's welfare. Okay? So they say, for example, that they're not going to pay you if you have the ability to pay for yourself. If you have money in the bank, if you had the Canadian Forces pension, which is property, as I said before, that means it has a means test instead of an income test. Now, I didn't mean to get into that, but you know, a means test is very invasive. It wants to know what kind of assets and income you have, and not just the income. So if you had to choose two, income testing is better, less onerous, less invasive. But the thing is, you shouldn't be investigating. You shouldn't be prying into a disabled veteran's life. It's not your business. Okay? Why isn't it your business? Well, they passed in the Pension Act, Section 108.3, which said that if a court order went across Veterans Affairs, somebody at Veterans Affairs desk, they don't have to respond unless there's two exceptions: a criminal case and an appeal of a Veterans Affairs decision. Then they can reply to the court order. Now, that is a very, very, very important indicator for us about how much Veterans Affairs values privacy. But then, on the other hand, you have a veteran, I think it was Sean Barea, Captain retired, up in Ottawa, I think he lives. Spoke to him a couple times. I think he had a major problem where Veterans Affairs breached his privacy. And I think it might have been the result of that in 2012, the Privacy Commissioner did an audit of Veterans Affairs. They reduced their privacy permissions for 95% of the department, but 500 had it removed totally. Now, that's not a very good indictment. That's not a very good thing to do. I mean, what does that tell us about the way Veterans Affairs views our privacy? In my own case, I've had this huge dispute about consent forms. Okay? When I applied for CISP, I signed for one on April 19, 2011. It gave them the authority to talk to everybody under the sun. Now, when I applied for the income replacement benefit, it was called ELB back then, in October, November 2012, because the CISP people didn't pay me until 2013, so I went to Veterans Affairs and said, listen, what are you going to do for me? These jerks over at D&D are not doing for me. What are you going to do for me? So they set me up in the rehabilitation program. But then they sent me a form that had questions that were asking me all kinds of prying questions, like, do you get a public service pension? Well, it's none of their business. None of their business. You might want to ask me if I get a Canadian Forces pension, because Veterans Affairs and Canadian Forces are closely related, but don't ask me about my public service pension. None of their fucking business. And then, did I get a long-term disability insurance? I get Sun Life through my CRA work, but that's none of their fucking business. So I told them so politely. Have a look at the forms I posted. Now, because I didn't send in the forms that they wanted, they didn't pay me the earnings loss benefit. Now, that's the subject of a major grievance for me, because they said that this is supposed to be automatic. In a 2009 report, or 2008 report that Veterans Affairs had on the internal audit, it said that earnings loss benefit is automatic upon approval of rehabilitation. Now, if you have an automatic benefit, ask yourself this, and again, I'll pick on Bud. I hate to do it, especially if he's, well, maybe he's watching, maybe he's not going to. Is it more expensive? Is it more costly to basically reinvent the wheel, right? Like, what do they need to operate? How can they do it lean and mean? The thing is, you should have been, according to, say, like the double dip clawback, all the government could have possibly justified as saying, listen, when they decided to top up the program in 2016, October, they could have said, okay, do you get the service income support insurance plan? Veteran answers no, they go through their normal process. The veteran answers yes, they have a program arrangement with D&D, first of all. then they should say, how much do you get? And then they can work from there, because they can assume that the Canada Pension Plan and the Canadian Forces Pension are being taken into account by the Department of National Defence to save money for the government, the taxpayers, under that Service Income Support Insurance Plan. But they went and operated as if the other department wasn't doing it, and I view that as a tort, perhaps, a negligence. They should have done it. Now, where I was going with that, I got a letter from the minister because I was asked for a minister's own motion. Now, that's a device where they can reconsider their own decision. Again, you had to be a big person to reconsider your own decision. Back in September 2019, and they said, you didn't sign the consent form, so we can't help you. And then I went and found the CISA consent form. And then I thought, if I was a person working at Veterans Affairs and I wanted information about Captain Retired Matt Edwards, service number Charlie XXXX, whatever, I almost said it out, but whatever. Anyway, they could call up the Department of National Defence program. They could call Manulife. They could say, listen, I want some information about Captain Retired Matt Edwards. Now, they could pull out the file on me. If they just see no consent form, they could say, I'm sorry, but I can't talk to you because there's no consent there. But if they pull out their form and they saw the blanket consent that I signed on the 19th of April 2011, they'd say, yes, but I got a consent right here. I can tell you whatever you want to know. So instead of sending me a consent form, they could have talked directly to the other department, which brings up Privacy Act, Section 82A. So Section 82A of the Privacy Act says that similar programs can transfer information between departments. Basically, it's common sense, right? Why would the government want to waste money getting the information twice when they already had the information it needs? Now, it can't provide information, say, for the Department of Fisheries to the Department of Veterans Affairs, because those aren't relevant. Those aren't similar. But the Department of National Defence CISA program and the Veterans Affairs Earnings Loss program, they're almost the same thing. So there's no reason you can't tell me that they couldn't share the information, especially when in 2016 the Chief of Defence Staff sent out a letter and it had an enclosure from Manulife and it contained all the information that we were supposed to provide to Veterans Affairs. Why couldn't they do that themselves? Why couldn't they transfer all the files from the people at Veterans Affairs, at the Department of National Defence program, and send that to Veterans Affairs to make things easier? Because it cost the taxpayer more money, because there was a 34% increase in the number of applications when they did that. I was talking to the Veterans Affairs manager at the time, and he told me they had a lot of overtime to try to address all these applications. Now, that took people away from their normal duties. So if you're doing your normal duties and all of a sudden you had these applications because the government decided not to transfer the information, but they decided to make you make a new application, and the government is costing the taxpayers money. And I, as a former tax collector, do not like that. You, as a taxpayer, should not like that. Why? If they waste money like this all the time, they're going to have to collect more. If they collect more, they're going to have to increase taxes. You're going to have to pay more because they're wasting it. That's why I'm doing this, okay? I'm not doing this to get more money. That's not the way I operate. So basically, the government should be operating as a lean, mean machine, in my mind. Veterans Affairs and the Department of National Defense should operate, they probably should combine the two. They probably should merge the two. And then there'd be no question about them sharing information because they'd be in the same department. And that just occurred to me. That's a new idea that I'm not going to put out later, probably. I mean, I might write it up, but I never thought about that benefit of merging those two departments. A lot of people might think that is a bad idea. I think it would be a great idea. You are entitled to your own opinion. I can say I think it will save money. I think it will be better on the privacy burden, the response burden, because that's what Treasury Board said. When they talked about the purpose of Section 82A in the Privacy Act, they said it was supposed to reduce the response burden to the citizen. Now, I think because you can often say things with more than one way, I think they could have said that, it's going to save the government money. Sure, it will reduce the burden on the taxpayer, the citizen, but in doing so, you're also going to save money because you don't call up the person. You don't have the person who's calling them, their salary dollars, eating up the time. And if they do it by mail, you don't have the mail and the return mail and then the processing of it. I mean, it's obvious that they ought to share as much information as possible, right? There's also an exception for those of you who go to the Member of Parliament. There's also an exception to a Member of Parliament who's trying to fix a problem for a constituent. They don't need a letter of consent. I mean, that's obvious to me. Because they're representing you. They're your legal representative in a democracy. You vote for them or you vote against them and they got more than your guy did. But they are your legal representative. Why should they, as your legal representative, have to go get a consent form in order to help you on a problem. If you go to them and ask for something to get fixed, then you have approached them. That's like an implied consent. You have asked them for help. Why do you need to give them express consent? I think everybody wants to cover their arse. Anyway, get back to me about the time thing, but I think I've been ranting and raving long enough now. If one of my fellows that I always tag in my groups, Donald Bohan, he said that my last one was one of my best yet. I think I'm getting a bit used to it, but I'm also getting a bit more upset about this. I mean, if I'm being a bit boring, it's probably boring to you guys too. But if I get more natural, like I'm talking to you in real life here, I'm telling you that this is what's happening, it's less boring, okay? I am not exactly the most charismatic person. I don't want to be, and I don't think I ever wanted to be. I think when I was going through a lot of my stuff to try to get benefits, I thought to myself, geez, they must think that I'm an Oscar-winning actor in order to get out of the military, based on whatever, or go to get my fitness to work evaluation at CRA because I was going through trouble with them. So they sent me for a fitness to work evaluation, FTW. And I saw the same doctor that I saw in the military all the time for my annual medicals. That was my worst fear. So I was afraid of going to the fitness to work thing because I might run into him. I ran into him, and the doctor gave me a 20-minute lecture about why I didn't tell the military about my depression. Now that was why I was afraid about going to the doctor. I was keeping it to myself just like everybody else because they don't want their career to be impacted. So I was diagnosed with depression in 2003. I was being treated with it. Funny thing was, I went to an Archon exercise, and a lot of my symptoms went away. Now you would think that a person who's a civilian employee and then goes to an exercise, a field training exercise where you simulate war, you think that would be more stressful than the shit CRA was putting me through. I've been put through hell by both Department of Veterans Affairs, Department of National Defense, and Canada Revenue Agency. One of these days I plan to sue CRA for $6.5 million. That's what I think they owe me based on what they did to me. And that's only the money, not including punitive damages and shit. The lawyer, when I went to talk to him, told me to try to keep it simple. Yeah, I mean, I can't help it. I know all this stuff. He also hired a lawyer to bring it in. I mean, I paid $7,500 in legal fees when I went to retain him. And everything I do gets complicated, this problem, right? Like, he brought in an external labor relations expert, because he's not a labor relations expert. And then the lady was talking about the way things are, and I had to put my hand up like a schoolboy and say, excuse me, but that's not the way it is. And they looked at me like I had 10 heads. I said, I work for CRA, and the public servants are covered under special laws like the Public Service Staff Relations Act and the Public Service Labor Relations Act and whatever. And you're talking about provincial law, provincial labor law, and if you go to court based on my case with the provincial law when the federal law applies, we'll lose at the very first level. So get with the program. Right? Now, do you think that expert, that specialist in labor law, like that? Do you think my lawyer liked that? I didn't care. I mean, I couldn't have my representative go down the wrong path and represent me in court. Now, he never ever took the case. But the thing is I also, kind of got caught up in the veteran stuff. So I decided to put that aside until I get the veteran stuff fixed. And if I get the veteran stuff fixed, hopefully that will also help me get my civilian employment stuff fixed. But I put the emphasis on the veteran because that's more important. Anyway, with that, I'll sign off and tune in again if you want in the future. And hopefully I won't make it too boring or too fast talking, and I got a accent evidently, my wife tells me. And but you don't hear your own accent, and I made a conscious decision years ago never to change it. Because, I mean, that's who I am. Anyway, thanks for watching, and hopefully I've brought up a few things that might prove beneficial, helpful. A lot of people don't want to know about problems, but I mean, ignoring the problem won't make it go away.